this court, in its experience, unfortunately, has to sit through dozens of sentencings on every week Monday, and you see the dysfunction and the things that happen to people. And while, again, it doesn't justify or excuse, you have certain people that sit before you that are absolute deviants. The reality is that he's gone through a lot. He has made a number of poor choices. His driving speaks for itself. He has committed to never drive. He has not driven a second since the day of the accident. That being said, there's still significant rehabilitative ability here. I really enjoy, not the right word, I respect, and I've tried to incorporate in my sentencing what this court usually says when it pronounces sentence, in that you balance the rehabilitative goals with the punitive elements, for each and every crime, the facts and circumstances of that crime. And certainly in this case, someone lost their life at a time that he did. The jury has spoken. I would ask the court to consider all of our sentencing memorandum, to consider my client's testimony under oath, and consider all those facts when pronouncing sentence. I think that certainly my client is aware that a significant punitive element must come. He is not sitting here asking that he be forgiven. He understands, again, I believe his level of self-actualization is much higher than most of my clients, and he understands that forgiveness may not ever happen, as we've repeatedly said in our sentencing memorandum. However, that being said, at some point in time, whenever the court deems it appropriate, whenever the parole board deems it appropriate, he's coming back. He's going to have an opportunity to rehabilitate himself. And I would ask the court to consider, the totality of these circumstances, not just the facts that give rise to the conviction, but also the lengthy history we've put in our sentencing memorandum, and fashion a sentence that it is just, and it does combine the two prongs the court always speaks of. And again, we're praying for the court's coming down with a just sentence. Thank you, Judge.
Thank you. Mr. Brown, anything you wish to say?
Yeah, Your Honor. As everyone in this courtroom knows, there's nothing I can say or do to change anything. I take full accountability for this. And, a lot of people, they think I'm not remorseful, but I am. I've been brokenhearted before today, before I heard them get up there and say what they said. And it hurt me worse hearing it. I hear about how great of a man Rene was, and I believe that. I know he was a great man. I never woke up that day thinking any of this would happen. Every day since, I've heard for this family. I know they hate me, and I understand. She asked if it happened to my kids, what would I feel? I'd feel the same exact way. But I am a good father, and I have raised my kids the right way. I understand emotions, and I understand what may look like, but not everybody grieves the same way. I've woke up every day, and I've blocked things out. Naturally I have. But it's still there. It's still, every day I wake up and I wish it didn't happen. I wish a lot of things. I wasn't even supposed to work that day. I don't even take that route. All this stuff just happened that day. And I can't change it. I can't take it back. I can't do anything about it. I take accountability for it. I know there has to be some punishment here. When I pray for me, I don't just pray for me, I pray for them too. If they don't, they may not want that, but I do, because I'm not a terrible person that they're painting me out to be, or, and I understand why. I do. I would be the same exact way. You know what I mean? But every day I wake up, I do try and be better. Every day, this has affected everyone in this courtroom. I can't imagine how they feel. It's terrible. But again, there's nothing I can do to take it back, and that I have to live with that the rest of my life. If there's any way to honor the great man that they speak of, I will, because that's just who I am. I never wanted this to happen. I I would never even expect this to happen. You go through life and you create a family and you have a job and all this and that. You don't think one day you're going to wake up and get in a tragic accident and countless people's lives are changed and broken, and you know, everyone in here is broken today. And all I can do is just pray for us all and tell the family, you know, I'm sorry. But what does sorry do? I'm not going to leave here today without saying it, but I know even though I say I'm sorry, it's not going to change anything. If they ever forgive me, they do. If they don't, trust me, I understand. I understand all of your pain. I understand how you feel. And I'm very sorry. And that's really all I can say. It's hard to even say anything right now.
Thank you, sir. Ms. Siderby?
Thank you, Your Honor. I obviously can't express the grief and sorrow that this group of amazing people haven't already said. But there are a few things that I'd like the court to understand and be aware of in its decision. As I read the sentencing memorandum talking about the remorse and how he's taking accountability, and then I hear his words today, I want the court to know what it's like leading up to today. I have some emails that were sent then to the jail with somebody currently in the jail, and the one sentence that really, really stuck out to me is, "The dude in front of me causes the accident, and they covered it up, used me as a scapegoat." This was dated March 27, Your Honor. The only person that Logan Brown cares about is himself. The only remorse, the only sadness, the only heartbreak that he has is because he's being held accountable. Maybe for one of the first times. When you look at his actions immediately after he caused the death, he calls and he puts the mother of his children in jeopardy, her job, by asking her to do something illegal and turn his insurance on. You look at the email that's in here leading up to today. You heard about the Facebook message. These do not show remorse. They show lack of taking responsibility. I watched the two videos this morning before I came up to court. It's been a while. We've talked about these. I hadn't seen them in a while, so I wanted to make sure I was accurate when I came up here for sentencing. These are two videos that were used for the buren case. And they were sent to us, and they said, "You just charged somebody. He's on bond for these. Here are these two videos we want you to watch." The first one is a woman sitting there holding the phone as he's begging for 5 minutes and getting very agitated, wanting to come into her house. And she said, "Go home. Go home. I don't want to talk to you. Come back tomorrow. Your eyes are dilated as blank. Go home. I don't want to talk to you." He keeps on going. He keeps on going. He keeps on going. At the end of the video, you hear him smash the door in. That was the home invasion. The other video that I watched this morning is him coming in. She's got the video up, same woman. There's a man in her kitchen. He has a gun, and he's pointing it at the man in her home, screaming at him about his kids. Obviously, the man must have had some contact with his children, so that was the way he decided to deal with it. It's important to this court to know this is what he's on bond for. This is a pattern. This is definitely a pattern. This crash was 100% preventable. There is no Twitter or Facebook or Snapchat that is more important than the lives of these people. And it wasn't just one, Your Honor. You heard the testimony about the in-focus apps. It was not just one. It was multiple, over and over and over, different apps being opened. And Your Honor saw all those signs leading up. All of those signs. All he had to do was look up once. look up once. Not to mention the huge pickup truck that was right there, which I would have hoped would have protected Renee, but just couldn't do it in this instance. These employees will never be the same. Many of them will probably not be able to do the same jobs that they're used to doing, and I've been informed many of them are in counseling as well. We think that the top of the guidelines takes into account his activity while he's on bond. It takes into account his lack of remorse. Like I said, the court can look at these emails. And it also then, more importantly, takes into account protection. Protection of the men and women who are public servants and who are out on those roads. And public safety needs to be a huge priority in this case, Your Honor. We think that the recommendations are appropriate and we have support to follow them.
Thank you.
Yeah, just briefly, I think, you know, and this is really for the record to be clear, I think the court does take into account, but certainly those actions in Berrien County, I would argue that A, he was admitted responsibility and pled guilty there and served his time, and B, I don't think, and I'm asking the court not to find that as being some sort of pattern that has to do with anything factually with this case. The reality of those emails that were mentioned, again, there are things that were discussed between me and my client that, in fairness, should have probably remained attorney-client privilege, but again, the court has heard from Logan at trial and today, and the reality is that he does take responsibility. It's just, it's never going to be, he's right. No matter what he says, it's not going to be enough, and it's going to be his actions going forward from now on that prove all the words he's given you. So again, we ask that the court fashion a just sentence.
Thank you. Well, I want to start with an apology because oftentimes I view my role as providing some form of closure to people or bring back some feeling of wholeness in your life. And in certain cases, I feel pretty inept at being able to do that, and this is one of those. There's nothing I can do to alleviate from what I've witnessed, the deep, deep grieving of so many of you. Defendant comes before the court having been convicted by jury of careless driving causing death and the misdemeanor of operating without security. He was acquitted by jury of operating while intoxicated causing death. My sentence will be, whether within guidelines or without guidelines, will be reviewed for its reasonableness. A sentence that is reasonable is one that is proportionate to the seriousness of the circumstances surrounding the offense and the offender. My goal in sentencing is to consider and attempt to properly balance punishment, protection, deterrence, and rehabilitation. In this case, there are various factors at play, some of which are aggravating and some of which are mitigating. The court has reviewed, first off, for everybody, a whole host of letters on both sides of the aisle here today and various materials presented. The court has also reviewed a sentence memorandum describing Mr. Brown's trauma-filled upbringing. While I won't recount all of the details, it is the type of trauma that could cause one as an adult to make poor decisions and exercise bad judgment. I've read a whole host of letters in support of Mr. Brown. Those letters reveal him to be a strong parent to his children. I recognize that imprisonment for any amount of time would harm those children. Many assert him to be a man of good character. He's described as an upstanding member of the community, one who volunteers his time and resources to various charitable causes. He serves as a coach for various youth sporting activities. He's provided documentation that he is in counseling with Mapleview Consultation Center, having attended 7 appointments since March of 2023. He's an active participant there, they say, having been diagnosed with various mental health disorders. These factors all lead me to hope that Mr. Brown has it within him to rehabilitate going forward, to the extent that this is a crime of carelessness versus intentionality, one can still reform, even if it means something as simple as being more careful and thoughtful in your actions and your choices. But here, in my review of the record, there appears to be more than carelessness. There appears to be a disregard, or at least a minimization, for life, for the life and the well-being of others. Of significance to this court is the fact that Mr. Brown was on bond for a felony offense at the time he committed this offense. This is not all that uncommon. But here, Mr. Brown was on bond for a home invasion and felonious assault, not theft or possession of drugs. These are victim crimes, and they are assaultive and potentially harmful and dangerous to others. While awaiting his day in court for those offenses, he gets in a car without security and is so careless through the use of his phone or otherwise that he blows right through a construction zone, killing a dedicated construction worker, Renee Rengel. The manner of death was described in detail at the trial, and I won't recount it here. I will note, though, that the horror and trauma exhibited by the witnesses who came upon Renee was palpable at the time at trial in their testimony on the stand, and impressionable to this court. The fact that Mr. Brown would so casually disregard the well-being of others while on bond for an offense which by its nature demonstrates a disregard for the well-being of others is a factor worthy of a focus on punishment as well as public safety in my sentence. I note, too, the pain and suffering Mr. Brown has through his carelessness inflicted upon others. His family, Mr. Rengel's family members, fiance, friends, and co-workers are living through their grief and loss. The senselessness of it all only exacerbates their pain, I imagine. Also, I recognize and appreciate that Mr. Brown has no obligation to admit guilt in this case. He maintains his innocence, and I respect and appreciate that. I will not and would not use that against him in my sentence today. Others, including the Michigan Department of Corrections, have focused not on that, but on Mr. Brown's lack of remorse as a valid reason for harsh punishment in this case. This is a separate notion from refusing to acknowledge guilt, and it is an appropriate consideration. I don't know if it is a lack of remorse or merely a self-interest that seems to supersede concern for others. But I will note that I am troubled by some of Mr. Brown's actions after the crash, and these have been brought up today. Almost immediately, his interest was in getting his insurance going on his car and putting his former girlfriend, I think she was, at risk of violating the law. I can't imagine that being on the mind of a law-abiding, conscientious person who just participated in an event causing someone to suffer a horrific death. It gives me some pause for rehabilitative potential. That same lack of concern for Renee and his loved ones is displayed in the jail email. It's a blatant lack of concern for the fact that someone has died, even if you don't believe it was your fault, that is also troubling in this case and worthy of a focus on punishment. Like the insurance phone call, the concern in those emails from the jail is about himself over others who have suffered a devastating loss. Deterrence, too, is at play in my sentence today. As some of the letters have emphasized, a message will be sent to others by the sentence I impose. I note that personally I've been more careful when approaching construction zones since hearing the evidence in this case. A sentence of incarceration today will further, in this court's mind, deter others from committing similar conduct and potentially harming or killing those out working on the very roads we have the privilege to drive upon. In balancing all of these factors, including the mitigating ones, I do find that a sentence at the top of the advisory guideline range is fair, reasonable, and proportionate. The sentence of the court is 86 months to 15 years with the Michigan Department of Corrections. You have credit for 178 days served. We'll order a restitution at this time in the amount of $253,616. Is that the total? 67. I'll do it this way, Ms. Idering, $250,000 to American Economy Insurance Company and $3,616.67 to Van Buren County Road Commission. Crime victim assessment of $130, $68 state costs. That's as to count 1. As to count 2, the sentence is 15 days jail with credit for 15 days served, $50 in state costs. Sir, you have the right to appeal the convictions and sentences. You have a right to ask for a court-appointed attorney to assist you in those appeals if you're financially unable to afford your own. If you do wish to make those requests, you need to fill out the paperwork I'm giving you now and turn it back into the court within 42 days of today's date. Jury has acquitted on the remaining count. Any other matters, counsel, to address?
I have nothing further, Your Honor. Thank you.
No, Your Honor.
Okay. Thank you, everyone.
Everybody stay here until people walk out, and I'll do this side personally, I'll be